Okay, so if we move on, we're going to talk about severance pay. And severance pay is a payment that is given to a worker when they leave a job. So this applies to all businesses, all workplaces in Korea. So everybody who's watching this should be getting a severance pay for their, if they've worked for at least 1 year at the current job. Now, how do we calculate severance pay? It's a little bit confusing, but if we take a look at this chart here, the way that we calculate severance pay is that we take the final 3 months of wages. So what's the average of the final 3 months of work that the worker has performed? So here we have the final 3 months of this worker's stay at their job. But in the middle, they took a month off because of sick leave. However, if we calculate the number of days, we have 61 days, and then we take the how much wages did they make? We take this and then get the average, which is the average daily wage would be 71,000 some odd won, and we're going to multiply it by 30 days, and then take the number of days that the worker worked at the company and then divide it by 365. So this would be the amount of severance pay that the worker should be getting. If we take another example, you can kind of look over this example a little bit more carefully. But like I mentioned before, in this case, the worker had a month off because of medical leave. So if we look at this list here, these are wages that are excluded from the calculation of the average basic wage, which is computed to determine how much severance pay we should be getting. So these are the different exceptions. Okay, some people who have left their job or are still currently working in their jobs, they have wages that are being unpaid. So this could include ordinary wages or additional wages or even severance pay. Definitely there is a system in Korea that's set up where workers can claim their unpaid wages. If there are wages withheld by the employer, the worker can file a complaint by going to the Regional Labor Administration Office. And then what the administration office will do is look at the different documentation and the testimonies of both sides, the worker and the employer. You will probably have to go in to meet with the employer and also the labor director. And then after the administrative office looks at all of the documentation and listens to both sides of the stories, they're going to settle the complaint. So in this case, in a successful complaint, the labor administration office will order the employer to pay the unpaid wages, and then that's when the worker will get paid. And let's move on to dismissal. So in some cases, unfortunately, an employer may dismiss their workers. In the situation where the employer has the plan to dismiss an employee, has the intention to dismiss an employee, it is absolutely necessary for the employer to give notice of dismissal at least 30 days before the dismissal. If the employer does not do this, then they are actually obligated to pay 30 days worth of the worker's wages. Now, there are some exceptions here that you can take a look at. Okay, next would be disciplinary action. Disciplinary action is taken when the worker has violated the obligations of the contract or the employment rules, or maybe the law. So in this case, what's really important is that the employer needs to make sure that the worker's misconduct corresponds to the grounds of disciplinary action that is stipulated in the employment rules. So if the reason for dismissing a worker does not relate to, it does not correspond to the grounds for taking disciplinary action, the employer actually can't process that disciplinary action. Now, if disciplinary procedures are stipulated in the employment rules or the collective agreement, not all workplaces have this, but if there are procedures, then these procedures need to be followed. If they are not followed, then the employer actually does not have the right to take disciplinary action against the worker. Now, if you think you've been dismissed unfairly at your workplace, there is definitely a system in place for you to complain about your dismissal. So what's important is that you need to request for remedy within 3 months after your dismissal. So after you've been dismissed, within 3 months, you need to go to the Regional Labor Relations Commission and then put in your complaint. If you're unhappy or dissatisfied with the evaluation or the decision that the committee has made, then you can, within 10 days, take your case to the National Labor Relations Commission. Now, maybe you're still dissatisfied with the evaluation or the decision made by the committee, then you can take your case to the administrative courts. Now, finally, we're going to talk about industrial accident compensation insurance. In Korean, you might hear people talk about what's called 산재. So this is a system that is put in place in the case that accidents occur while we are working. Now, what's important is that in 2018, what is also considered work-related accidents is accidents that occur on our daily commute, so to and from work. So this is something that's been added. Now, when there is some accident at the workplace, if you've been injured at work, then you can actually request medical care benefits. So this is the form that you would be using, and you need to be as detailed as possible, obviously. And then also it's really important to testify with accuracy if you are at the police station or at the emergency room, etc., when you are applying for these benefits. These are the different types of occupational accidents. Obviously, these are, very, very serious occupational accidents resulting in death, but there are also a wide range of accidents and occupational diseases that Korea considers as workplace work-related. Okay, just one more thing. So if we are requesting compensation for an industrial accident, we can ask the Workers' Compensation and Welfare Services to look at our case. So if I have applied for medical benefits and I have been denied, or I'm unhappy with the initial decision made by the Workers' Compensation Welfare Service, then I can actually appeal the decision. I have 3 months to do it, 90 days to do it, and then the Welfare Service will re-review my case. Now, we're still unhappy, then we can also request an additional examination. And then if we're still unhappy at this point, we can then take our case to the Ministry of Labor, Employment and Labor Industrial Accident Compensation Insurance Reexamination Committee. So this is a committee that will take on a case to review that has already gone through this process, the first process. Okay, and then finally, if we're still unhappy with the decisions made by the committee, then we can take this to the administrative courts. Okay, so everyone, how was it? Do you understand about Korean labor law a little bit more than before? Thank you for taking the time to watch this lecture, and for those who are still confused, please contact the Gyeonggi Institute of Policy and Research Development for Migrant Human Rights. Thank you.